All right, let's make this an opportunity to make the public understand, no? Sinabi ng defense team, unconstitutional na po ang ginagawa ng House Committee on Justice na meron kayong quote-unquote mini trial. All right? So let's talk about this. Under the Constitution, what we know of is the House Committee should decide if an impeachment complaint is sufficient in form and substance. Nagawa nyo na po yun. Ito merong sufficiency in grounds. Ngayon lang po natin ito nakikita kasi yung dating sistema, botohan lahat ng 1/3. Okay? Are you going beyond the mandate of the House Committee on Justice?
No. Doon sa binanggit mong provisions ng ng Constitution, meron din diyang sinabi that the House of Representatives is granted with the power to promulgate rules on impeachment, no? And that is the rules which the House of Representatives adopted even in the past impeachment processes. This is the same impeachment rule also which was used in the 19th Congress. And since now is the 20th Congress, in the resumption of the 19th Congress, of the 20th Congress, inadapt yan, nagkaroon ng formality sa plenary that the 20th Congress is adopting the 19th Congress rules of impeachment. Hindi po ito bago. Hindi po ito labas sa konstitusyon, ito po'y ayon sa kapangyarihang ipinagkaloob ng saligang batas sa mababang kapulungan na maglatag ng rules of impeachment na ginagamit na sa mga nagdaang proseso, ginamit din sa 19th Congress at inadapt ng 20th Congress. So
isang bagay na malinaw is the House can actually make their own rules when it comes to the hearing the impeachment complaint. Tama po yun.
Tama yun. At yan ay maliwanag sa ating Article 11 dito sa accountability, which addresses the provisions on impeachment. Pinagkalooban ng saligang batas ng kapangyarihan ang House of Representatives na gumawa, maglatag ng rules of impeachment to realize the impeachment process which was pronounced in the Constitution as well.
Okay. So technically speaking, you are evaluating if the impeachment complaints have probable cause. Parang piskal, parang ganun po yan.
That is correct.
But are some of your colleagues going overboard? For example, I mean, you have Representative Rufus Rodriguez already commenting on the credibility or non-credibility of a possible witness, of calling a witness, let's say, tainted or untainted, then you are already nagsasabina na po kayo ng what may be considered as possible evidence that could be used in the impeachment trial. We have never seen this before. Is this already going beyond the bounds of what the House Committee on Justice should be doing?
This is not beyond the bounds of what the Justice Committee is supposed to do. We are simply following our rules of impeachment. And it is very clear under Section 7 that after the determination of sufficiency in grounds, we shall proceed to our hearing proper. Hearing proper is the exact terminology that was used in the rules of impeachment. It was stated there that the compulsory processes may be exercised for the purpose of issuing subpoena duces tecum, that is for documents, subpoena ad testificandum, that is to compel the attendance of the witnesses, and it even made mention na yung pagtatanong, examination and cross, this will be done by the justice members. Even saying that the chair or the presiding officer can limit, manage, regulate the time of the justice members in raising questions. No? So, eto pagka inanalyze mo to, Karen, all of this are processes akin to a preliminary investigation. Tama ka sa sinabi mo kanina. And the most significant part of that is the purpose of this clarificatory hearing really is only to determine probable cause. And the definition of probable cause is justification to be able to proceed to trial. We cannot compare this to, I mean, if you compare this to the proceeding in the Senate, yun talaga yung actual trial, the purpose of which is to determine the guilt and the innocence, and after which, if found guilty, it will be the implementation of the necessary penalties, no? While I use the term mini trial.
Oo. Do you believe now that you used, I mean, now that we're having this discussion, frankly speaking, do you believe that it was a mistake to use mini trial?
I don't think so, because it was intended to make a clear distinction between what the people are watching in TV with respect to the trial that is happening in the Senate. Because how else will you explain that to the ordinary people? Ang nakatatak sa isip ng tao ay yung trial ni President Estrada, trial ni Chief Justice Corona, because they've seen this in televisions. And in my effort to reach out to the grassroots, because after all, this impeachment process is an extraordinary power that was given to the Filipino people. I use mini-trial to make them understand, ito pala maliit na proseso compared doon sa nangyayari sa Senado, which is the real trial, no?
Oh, but this is not a trial. That's the problem. What you are doing is not a trial, right? I mean,
correct.
A trial determines guilt or innocence. So technically, the word trial is wrong.
Perhaps it is misplaced, but it has reference to a structured process of investigating and giving opportunity to both parties to present the respective evidence, no?
Kasi you could have just used probable cause hearing.
Do you think that is
Another term.
do you think the preliminary investigation thing, the clarificatory hearing thing, what did you say? The probable cause thing.
Probable cause hearing. Oo.
Are this easily understandable to the grassroots, the ordinary Filipino people? I think
kasi ang mini trial can have legal implications. That's why tinanong ng reporter, will you take this to the Supreme Court? So baka sumabit ulit kayo. 'Di ba? Yun ang tanong.
We cannot stop them from bringing any stage, any nomenclature, any proceeding, any step that we are doing in the Justice Committee to the Supreme Court, because that is their prerogative, that is their right. However, Karen, even assuming that the term mini trial is misplaced, is it correct to bring that mini trial to the petition, by way of petition to the Supreme Court, when in fact what is happening in the Justice Committee is a clarificatory hearing? I've said this in the hearing yesterday. I said that the proceeding should be judged not on the basis of the name, not on the basis of the nomenclature, not on the basis of the label. The proceeding should be judged on the basis of the actions that the Justice Committee do during the proceeding in the hearing proper, quote unquote.
Okay, so let's call it a clarificatory hearing, no? Para sa akin kasi malinaw na it's looking for probable cause. So let's go to this. You have issued, you took a vote, right? Humingi ng boto at nagpasabina kayo. You're gonna issue sabinas. Let's talk about the sabina to one of Vice President's Duterte's lawyers, Attorney Michael Poa, all right? Sinagot nila that they did answer. One, for whatever reason, they did reply, right? They did reply. The non-reply reply is their interpretation is a response. So that's number one. the Vice President not attending the hearing, they may have a point and say, what makes that any different? Si former President Estrada, hindi naman nag-attend. Si Corona, si Gutierrez, ang dami, hindi naman nag-attend sa any House hearing. Right? Kumbaga, it was brought directly to the Senate. So they may argue that's not a form of disrespect because they did reply, right? That is not a trial. So when you call Attorney Poa, what does the House expect from him? Why do you want him there?
Well, from the point of view of the justice members, most especially the proponent, it was Congressman Tino, right? He believes that Attorney Poa, as then COS of DepEd ba yun or OVP,
Yeah.
played a significant part, even if not through the document, but by action in the utilization, alleged misuse of confidential fund, no? At alam mo, Karina, one thing, sorry,
Karen,
alam mo, Karen,
it's okay,
sorry.
no problem.
One thing that we must understand here, the committee is a collegial body. All decisions are done by way of majority vote. So,
Okay.
since ganito yan eh.
Oh, but Representative, but Representative, etong tanong. So Attorney Poa goes there. I'll give you a scenario. He refuses to answer questions. He'll say, I don't believe that this is the forum. Right? Let's say hypothetically, you have to remember they have a defense strategy. I mean, I don't know what it is, but what if Michael Poa will be used as a witness in the trial proper? Because you yourself said he was in a position then, right? During that time, he knows where the funds were spent. So he may not be one of the lawyers in the hearing, in the trial proper, but they could use him as a witness. We don't know that. But by bringing him there, o sasabihin ng kasamahan mo, we will cite you in contempt for not responding. So that's when this gets blurry. He can choose not to respond. He can choose not to cooperate because it could be a part of the strategy. This is why ang tanong ko, what is the role of the members? You know, he can choose not to answer.
The members are
but
the
you know what? A
investigators.
person can choose not to respond. It is within the right of any person to choose not to respond because that is not a trial. Kaya yan yung tanong ko eh. Aren't you already crossing the line at this point by you're actually, ang pinapasabi na nyo are probable evidence, ha? Nandun na kayo eh. So, yan ang tanong ko. Okay, what if Attorney Poa refuses to respond? Can you cite him in contempt? That's a basic question. Can you?
He has to cite the ground for refusing to respond.
Okay, so a
no?
possible response, Mr. Chair, I cannot respond because this will be part of the evidence in the upcoming trial. By responding, we will be handing out our strategy. As a team, we have decided not to respond in this hearing. O paano kayo ngayon?
Because they are not recognizing the constitutionality of
Not
the
necessarily.
proceeding. Is that the
They
reason?
can say, we recognize this, but I am limited. I cannot give out details. O
Well,
paano yun, ma'am?
it will depend on the members of the Justice Committee. May rules tayo. Inciting
But how far can you go?
resource
Yan ang
persons
tanong.
in contempt, no? It
Okay.
will depend on how the justice members will be reacting to the failure or refusal of the resource person or the witness to respond.
Because let's say you cite a person in contempt, i-detain nyo, ipapakulong nyo. Hindi ba trabaho na yan sa actual impeachment trial? Parang you are really acting like a court. That's my question. If you go this way, I have another question. You bring in the SALN of the Vice President, right? That Representative Redon says increased by a hundredfold. I'm reading it right now, okay? Which is fair, okay, that her SALN increased from 2007 to 2005, I believe. Yun ang contention. Okay. The SALN in itself is not a crime, right? But she has to defend how her SALN increased. O eto tanong ko, ma'am. By defending it in the House, is not that already a trial?
He is part of the investigators, and it is incumbent upon him to know the truth behind his allegations. It could be belying the allegation in the complaint. It could be proving the allegation in the complaint. So itong mga searching questions, no, which will be raised on the basis of this
Because-
SALN by
because let's
Congressman
say-
Ridon will have no certainty yet as to its result, diba? So what is being done here really, or what will be done by the investigators or the justice members, are to raise questions, to investigate whether there is basis really enough to constitute probable cause in the allegations in the complaint. Remember, Karen, na-declare siyang sufficient in form, na-declare siyang sufficient in substance, na-declare din siyang sufficient in ground. Under the rules,
So
and
why
even
not send
under
it to a vote already? It's already been declared sufficient in
Because
grounds.
it is in the
Why not
rules.
send it to a vote? That's the
Because
question.
it's in the rules.
Because
And the
then you
rules
have...
provide for a hearing proper.
Okay,
What are we
but
supposed to
ma'am,
do?
But ma'am, isn't this also an opportunity for grandstanding to actually
No.
elongate the hearing? You know,
No.
instead of the vice president having her day in court in the Senate. And frankly speaking, I'm being objective here. These are legitimate academic questions that are now being taken up by law students if the House Justice Committee is going overboard. Yun yung tanong in classes today.
How can we be overboard if what we're doing are all in the rules of impeachment, which has been the rules since the past impeachment processes, no? And how can we do away with this process when it is provided under the rules that we're supposed to conduct a hearing proper, to issue subpoena, to question the witnesses for us to be able to be guided? Kung may probable cause ba o wala. I was discussing this with the justice members yesterday. Anong sabi ng mga justice members? Kung hindi tayo mag-hearing proper, kung walang presentation ng evidence, kung walang issuance ng subpoena, how else are we going to determine the existence or non-existence of probable cause? And no way that we will be deviating from the rules, because we are really, admittedly, being very cautious after what happened in the first impeachment. I think the justice members are all very careful to make sure that we follow strictly what are provided in the rules. Ang sabi ko before, dun sa one of our hearings to Paulo Marcoleta, everything that I am saying is in accordance in the rules. Well, at least in as far as what is happening in the justice proceeding is concerned, no?
Yes. I think that one is clear. You have really shown that yourself. You have been cautious. You have been extra careful, right?
Correct.
Okay, with you yourself as chair in how you are handling it, I don't think that's a question because it's a live coverage. We're all seeing it. But here's a good one for you. So let's say the SALN is subpoena. Dumating ang SALN. Tatanungin nila, please explain why the vice president's assets has increased in the last so and so years. Basic question, right? Where did the vice president get her income, her wealth? Sasagutin kayo. Madam Chair, we will present the proof of the vice president's increase in income when we reach the trial proper.
Well,
Paano
again,
ngayon?
it will depend on the justice members how they will react to that answer of the witnesses. But I think it's only the vice president who can answer really in matters concerning the SALN, no? Kasi siya lang naman ang may personal knowledge dun sa SALN eh. If she will continue not to appear in the justice hearing, I don't think that the members will have the opportunity even to ask that question. It cannot be asked from the other witnesses because it is the vice president who files the SALN. So she and only her has the personal knowledge about the preparation of that SALN.
Okay, Madriaga, of course, you have made sure there was a vote that Madriaga be called, right, to the House hearing. And Representative Shell Diokno actually made it clear that he was worried already for his safety, right? And you said you would guarantee that safety, which is quite fair. So when Madriaga arrives, right, and he is questioned, so I can imagine how hearings go. Tatanungin, anong alam mo? May personal knowledge ka ba dito? Etc. Right? So he would obviously state what he would claim to know or what he knows. The question is this. The team of the vice president, are they allowed? They're not allowed to correct him, right?
You're asking about
Let's say Madriaga speaks and says, nakita ko ginawa to ni Vice President.
We cannot-
Halimbawa lang po to.
Yeah,
Pinapatay niya to, ginawa niya to, inutos niya to. So he's speaking. Can the defense team, what can they do? Because obviously you will ask these questions. None of us will know if he's speaking the truth or not until it reaches a trial proper. And the senators will ask, as judges, can cross-examine him. Kasi are you allowed to cross-examine in the House
with all due
Justice
respect,
Committee?
with all due respect,
Oo.
Karen, no? Perhaps it is a special skill of an investigator or even a senator judge to know really whether the person is speaking the truth or otherwise, no? So I think it is quite unfair to say that the only time when we will know when he is really speaking the truth is pagdating ng trial, because we cannot tell if this congressman in the Justice Committee have that special skills, no, similar to a well-versed prosecutor, that he can really tell this man is telling the truth, this man is telling a lie. No, it depends on the person raising the questions. It's actually a special skill that is distinct to the members of the Justice Committee. I cannot tell that all of them have that kind of skills, but at least whatever will happen in the presentation of Madriaga will help them decide about the existence or non-existence of probable cause. And let us also consider the fact na itong probable cause naman, this is not guilt beyond reasonable doubt. This is not substantial evidence. This is not preponderance of evidence. Ang sabi sa mga decisions on impeachment, by probable cause in the impeachment process, it only means justification to proceed to trial. No?
I think we are one with that. That's why many are asking, why not just proceed to trial? Even the defense team of Vice President Sara Duterte is asking that. Bakit pinapahaba? Sufficient
Remember,
informed. Kasi sufficient na informed, substance, and in grounds. Ano pang dahilan para hindi yun magka-probable cause? Kayo na mismo ang bumoto na sufficient na may grounds. So ano pa ang ang tanong nila, ano pang hinahanap nila? Sila na nga mismo bumoto na sufficient na to in grounds.
Okay, let me explain that. When we conducted our hearing on the determination of sufficiency in form, what we are trying to see is whether my verification, under oath of verification, may accompanying resolution ang House member at under oath of resolution. That's the parameter. Pagdating sa sufficiency in substance, we are supposed to confine the determination to the complaint and its attachment. The parameter is whether the recital of facts constitute an offense determinative of the jurisdiction of the Justice Committee. No? So it's the complaint that is the basis. Pagdating ng ground, we are supposed to evaluate the responsive pleadings. No? Pag sinabi nating responsive pleadings, you have to read and study the answer. if this is responsive to the allegations of the offenses and grounds. Nasagot ba ng answer ng Vice President ang mga aligasyon doon sa complaint? Apart from this answer, we're supposed to study and evaluate as well the reply, which is the answer to the answer, and the rejoinder, which is the answer to the reply. However, natapos na nga sa answer. Kasi nag-waive na ang ating complainant because ang sabi nila, wala naman palang sagot yung answer, so we will not be filing a reply. In other words, dito sa ground, hindi lang tayo nakakonfine sa complaint, we are considering as well the responsive pleadings, and that includes the answer. No? Pagdating ng fourth, the difference, Karen, is under the fourth step, we are supposed to weigh, study, scrutinize, listen, and evaluate the evidence presented by the complainant and the evidence presented by the defense or the respondent before we come up with our decision whether or not may probable cause ba, no? Pagdating naman ng probable cause at may, in the affirmative and naging decision, that's where the transmittal will happen and the full-blown trial or the trial, the real trial will happen, no? Again, I do not want to be misquoted again. What's happening in the Justice Committee is akin to preliminary investigation. Perhaps the proper term is hearing proper. Kasi yun ang ginamit na term sa rules. At yung, to your question, Karen, bakit pa kayo mag-hearing proper? Bakit hindi pa dalhin nyo na lang doon sa Senate? Total, may sufficiency na in form, in substance, and in ground. Eh, paano yung rules? What if we accused of violating the rules? Diba? That's one. Eh, ang liwanag sa rules, conduct hearing proper. And if we skip this process, definitely, we are a perfect subject matter of another petition to the Supreme Court. Diba?
Okay. So,
pangalawa, I just want to re-echo what the justice members are saying. We are mandated to determine probable cause. How do we do this kung walang hearing proper? How do we do this kung walang presentation of evidence? How do we do this if we will not examine the evidence of both parties? And remember, this subpoena is also provided in the rules of impeachment. That's part of the compulsory process of the Justice Committee.
Okay, all right. So you've made that quite clear. Now, I have a question with what you've said. You've said that once the House Justice Committee makes a decision, if there's probable cause, it's transmitted to the Senate. Does that mean that with this process, hindi na ito dadalin sa plenaryo tapos may 1/3 vote? Or dadalin
Dadaan,
pa rin?
of course, sa plenary. Okay. So,
dadaan pa rin.
this is what's gonna happen, no? After the hearing proper, the Justice members will vote whether or not there is probable cause. The required number of vote is majority of all members. Hindi majority ng present, ha? Majority of all members. That is different from simple majority. Now, if the vote is in the affirmative, we will be preparing a resolution. Attached is an articles of impeachment, which we will, along with the committee report, all of them together will be transmitted to the plenary. I will be reading the report. I will be defending the decision of the Justice Committee. Tapos, perhaps there will be some question and answer that will happen in the plenary until the members of the House vote on the approval or non-approval of the committee report along with the resolution and the articles of impeachment. But the thing is, the required number of vote is at least 1/3, no? I lost count kung ilan na kami, pero I've been hearing 106 daw ang 1/3. So perhaps we have 308, we are 380 now in number, no? So, ano bang consequence? Pag hindi mo na-achieve yung 1/3 vote, at ang committee report mo is existence of probable cause, that is tantamount to dismissal. Pero pag na-achieve mo ang 1/3 vote doon sa committee report about the existence of probable cause, it means that the articles of impeachment will be immediately transmitted to the Senate for trial.
So technically speaking, I mean, this is both a legal and a political exercise. We know that, right?
Precisely, Karen.
Yes, but at the end of the day, I think you and I admit that to send this to the Senate is a numbers game. It's a numbers game.
Okay.
Because you may find probable cause, but then hypothetically, if times were different and it was a Duterte-supported House, then it may be dismissed. Kahit na may probable cause, they can vote not to send it. But if hindi, without reading it, they can also say, let's send it. Kasi 1/3 is very small. That's not a
Correct.
lot. That's not majority.
Correct.
So I think we agree on that this is political too at the end of the day, that it's a numbers game. So my next question is, can the House, because technically you are already gathering evidence. That's what you're doing. Nagsasabi na kayo, you asked for the video, which of course we've all seen, right? Let's say they ask, what was the motive? Is that allowed? Let's say, what was the motive of the Vice President in threatening? Ba't niya nasabi yun? Etc. She is not there. She won't be there. What happens with that video that nasabi na nyo, that's actually all over? Do the House Justice Committee members say, that constitutes as a ground, that constitutes as evidence, because I'm curious, what power do they have, really?
So it is on the last step on the preparation of the articles of impeachment, where we are supposed to consider the evidence which will be provided for the purpose of transmitting the same to the Senate or supporting the articles of impeachment. And it will happen only after the entire hearing proper, no? Kasi after the determination of probable cause, the Justice Committee now has a stand.
Okay.
We will be standing to defend the articles of impeachment. That's the thing, no? But prior to the determination of probable cause, Karen, we are investigators. We are trying to raise searching questions and clarificatory questions. Let us not use other term. Clarificatory questions which will eventually guide us. May basis ba for us to proceed to trial? No? Ngayon, to be very clear, wala pang stand ang Justice Committee. But once we are done with the voting on the probable cause and we voted in the affirmative, then I can say that the Justice Committee's stand is on the existence of probable cause, and we will be supporting the articles of impeachment.
Okay. So now the committee members are investigators, but there is a big possibility that one day they will be prosecutors. So they take on different roles. You have some representatives who are also complainants, right? Of the Vice President. I believe, tama po, di ba, si Representative Laila De Lima.
She's an endorser.
Oh, she's an
Endorser of the complaint.
Oo.
Yeah.
Si Shell Diokno po is an endorser or
No.
complainant?
No, he is a justice member.
Okay. And what about Representative Tino?
Tino is a justice member.
Okay.
Ex officio member, I think.
Oo. So si Representative De Lima lamang ang endorser.
Wait, to be accurate about
Oo.
Representative De Lima, she is
Parang
both an
complainant din.
ex officio member siya and endorser at the same time.
Okay. And not a complainant.
Not a complainant.
Okay. So right now, they are endorsers, they're investigators, but one day, many of them could be prosecutors. Right? Is there anything under the rules that prohibit that?
I didn't see anything which says that an investigator or a justice member cannot be a prosecutor. Walang ganyang prohibition.
Walang ganon. And I
And
think-
remember, Karen, if I may add, no? Ito namang pagiging prosecutor, we don't volunteer. We're being elected by the plenary. It's the members of the House of Representatives that elect the members of the prosecution panel.
Oo. Kasi I think you're in a very interesting position because you were with the Quadcom hearings in the past. You were slated to be a one of the lead prosecutors. Because in a way, you actually came to some form of national prominence, really because of the Quad Committee hearings. And now you are the chairperson, which you are called to impartiality, right?
That's correct. That's correct.
Ang tanong ko, hindi ba awkward yun kung chairperson ka ngayon? Tapos, halimbawa, in the future, maging prosecutor ka? Then,
Well,
the defense,
Karen,
diba? That's it.
yeah, I think it's very clear that the impeachment complaint in 2025
Yeah,
is
was
entirely different in the
okay.
impeachment complaint that is being heard now in the Justice Committee, no? Even granting that the grounds are almost similar, the manner of hearing it will depend really on how they drafted the impeachment complaint, the evidence that will be presented, the witnesses who will be testifying, no? And let me add, for the record, ang chairperson po, she doesn't vote. The only opportunity when the chairperson votes is in cases of tie. Now, in the event, pero ayokong i-claim, in the event that dadating ito sa trial, I don't see any conflict about that because, as I have said, after the determination of probable cause, and it is in the affirmative, the official position of the Justice Committee by then is already in favor of probable cause, and that is to support the impeachment process.
All right, ma'am, 2 questions na lang. We don't have enough time, but I don't want to go without this. Is it true, I interviewed Representative Toby Tiangco yesterday, that you are changing the rules, meaning the House Justice Committee, that non-members can no longer ask questions?
We are strictly following the rules. So with all due respect to Representative Tiangco, perhaps he should read. It's very clear under the rules that the time for examination, this is the verbatim, the time for examination and cross-examination of the justice members may be regulated by the chairperson or presiding officer.
Yeah.
When the rules made mention about justice members asking questions, examination, and cross, it has only one interpretation. That only the justice members can ask questions. I don't think there is other. It was never changed. It was never changed.
Okay. My next question is, you have a limit or a maximum of 60 calendar session days. Tama,
Correct,
ma'am, no?
correct,
Okay.
correct.
And if you are going at 3 times a week, you can correct me on this, technically you can do this for 5 months.
3 times a week, that will be very, very burdensome, no? 3 times a week. Kasi right now, we are doing it once a week.
Oh, wow.
And
So
we have a
that's
long
if it's
interim from
put
today.
60,
From today, our next hearing is April 14. Kasi ang problema namin dito, Karen, the challenge of pulling the justice members together for them to sit in the Justice Committee hearing. Remember, it's recess, di ba? But because this is a constitutional duty, talagang we are trying everything to make sure na at least makomply namin itong 1 hearing per week beginning on April 14. Medyo kinonsider din namin itong Holy Week kasi baka mahirapan kami, not only with respect to the justice members, but even with the parties in the impeachment complaint. The complainant, the witnesses, and even the respondent and their witnesses. That's why our next hearing will be April 14. No? About
So,
your question about the
kung
6
60
months.
60 calendar days. I mean, honestly, now that you told me that it's once a week, I calculated it at 3 times. Then technically, this can go on till the end of the year.
That's correct. Because we are following the definition of the Supreme Court. Ano ba sabi ng Supreme Court in the resolution of January 2026? Session day is a calendar day whenever the House of Representatives holds sessions. Remember, now is recess. No? So, let's leave it up to the opinion of the public. Ito bang ginagawa naming hearing ngayon? Is this chargeable to the 60 session days? Nevertheless, Karen, we are very careful. We're very much conscious about that 60 session day period and will make sure na hindi kami lalampas dito sa 60 session day period.
All right, because imagine if there's like a probable cause hearing, I will call it that, a probable cause hearing that will extend till the end of the year. I mean, isn't that, don't get me wrong, unfair to number one, the accused, the impeachable official, to the Filipino people? You are technically spending money of the Filipino people, and let's face it, the time. You know, the Filipino people want this done because there is an oil crisis. You know, ang daming ibang problema. So kaya ang tanong is, you know, at the end of the day, it's focus. The nation, you're taking away focus from real problems if this probable cause hearing goes until the end of the year, and then hypothetically she gets her impeachment trial already by next year, which is the filing for presidential candidates. Right?
Definitely, Karen, it will not take 1 year. Why? Because there are only, when summarized, there are in fact 3 offenses only. No, it's
Okay.
it's the confidential fund, the issue of corruption, and then the threat, and then the what's the last one? The unexplained wealth. If you summarize. So, kahapon, napansin nyo din during sa hearing, nag-propose si DS Kong Hon, if we can do the presentation of evidence altogether with respect to these allegations because they pertain to one offense, no? That
Okay.
is confidential fund and bribery, no? So, I don't think it will take 1 year. And about spending the money of the Filipino people, yes, of course, because this
And
is
the
part
time,
of the...
and your time. And your
Yes, our
you know.
time. But you know, Karen, this accountability has something to do with the state of our country today and on the coming days, no? Kapag ang ating leader ay honest and accountable, I think we will be on a best position. But if our leader is not honest and not accountable to the people, then it will be worse for the Philippine nation.
All right. Okay, but when we talk about accountability of leaders, I personally believe there are so many other leaders that should be held accountable too, right?
But this is impeachment.
Yeah.
This is impeachment, no? If we will be talking about other leaders who should be held accountable, they should go to the ombudsman.
Yeah.
This is impeachment process, and that is why I am very strict with regards to the manifestation of the justice members. Make sure that you confine your manifestation to the subject matter of this impeachment. We are not saying that the other public officials are not accountable, but the impeachment process is definitely not the proper forum for the other public officials.